Oh, okay. Thank you very much. Good morning and welcome everybody. I'm very pleased to have been invited to chair today's international conference, which is a part of the research project of national interest on the Belt and Road Initiative, whose acronym is BRI, directed by Professor Stefano Zunarelli as principal investigator. Before starting, I'd like to give you some background information. As is well known, the BRI initiative was launched exactly 10 years ago, in 2013, by the Chinese President Xi Jinping, and was meant to be a call for international and transnational cooperation in 5 areas: policy coordination, infrastructure connectivity, trade facilitation, financial integration, and people-to-people bond formation. In particular, the World Belt refers to the land-based Silk Road economic belt, which is the project to link China with Central and West Asia, Southeast Asia, Russia, Europe, the Persian Gulf, and the Mediterranean Sea, with railways, highways, and fiber optic cables. The World Road, echoing the ancient Silk Road, refers to a 21st century maritime Silk Road, namely a sea-based project to link China with the seaports, coastal lines, and markets in the Mediterranean Sea and in the Pacific, Indian, and Atlantic Oceans. The World Bank has defined the BRI initiative as an effort to improve regional cooperation and connectivity on a transcontinental scale, which aims to strengthen infrastructure, trade, and investment links. As has been noted, I quote, "The sheer size of the economic activities in the BRI area would for sure generate tremendous need for cross-border dispute settlement. The amount of goods, services, capital, actors, regulation, and cooperation involved in BRI, which in most cases is international or transnational in nature, undoubtedly would produce immense demands for dispute resolution concerning commercial transactions, investment, energy development, construction project, environmental protection, labor relations, taxation, payment, and regulatory compliance, among other issues," unquote. At least two types of disputes have arisen as a result of the implementation of BRI initiative. On one hand, we have investment disputes in the form of state-to-state or investor-state disputes. And these kinds of dispute might be resolved by behind-the-door diplomacy, or by ADR instruments, like investment arbitration and or mediation in the framework of existing or newly negotiated bilateral or multilateral investment agreements. It is worth mentioning that the CAI, the bilateral EU-China Comprehensive Agreement on Investments, which has been the subject of ongoing negotiations since 2014, doesn't have an investor-state dispute settlement mechanism for investment agreements, and this could deny investors seeking compensation if either party breaches their commitments. However, CAI provides a state-to-state dispute settlement, a so-called SSDS mechanism, namely for arbitration between China and the EU. It is a similar procedure to the WTO one, but without the right to appeal, and also dictates the procedural rules thereof. And these rules cover a wide range of matters, from commencement of arbitration to the cost of the proceedings. And this would mark a move toward institutionalizing the procedure for state-to-state arbitration, in contrast with China's past bilateral treaties with the various EU member states. For instance, the China-Germany BIT does not contain any agreed procedural rules, stating instead that the arbitral tribunal shall determine its own procedure. On the other hand, with BRIE, there might be traditional trade disputes, which would be essentially transnational in kind and might involve resorting to established international ADR institutions and agreements or ad hoc arbitrations. It has been suggested that we might consider investment disputes and international trade disputes in the BRIE area as BRIE disputes. In other words, as a third kind of BRIE-specific dispute whenever, I quote, arising out of a project or transaction that was created in relation to the BRIE. For example, a China-invested project or a joint venture between a Chinese investor and an investor from the host country. As is known, in 2018, China decided to establish its own dispute settlement bodies for so-called BRIE disputes. Today's conference topic, that is the ADR instruments applicable to the different kind of disputes that might arise from or in relation to the BRIE initiative, concern the aforementioned issues and their implications in terms of the law. Indeed, investor confidence and the success of BRIE integral purpose of economic integration depends on the universal acceptance of and mutual trust in legal dispute resolution instruments. So, as Elena has already told, note that there will be time after all the presentations for a couple of questions, depending on the time left. Those who would like to ask questions should send their question to Elena Roux through the Zoom chat. And now, without further ado, I leave the floor to Professor Susan Walker, who will discuss the topic arbitration for BRIE-related disputes, settled or disturbed relation landscape. Susan is course leader of the postgraduate diploma in international trade and maritime law in Solentay University's Worcestershire Maritime School and course leader of bachelor science course in shipping, trade and transport at HST Academia Hamburg. Please, Susan, the floor is yours.
Good morning, everybody, and thank you to Chiara and Elena for inviting me to speak at the conference. I have confined my thoughts on trade-related disputes rather than state-by-state disputes. I think the time allowed and the complexity of both sides of the coin just do not allow me to deal with both. I do think, on a comment that Chiara made, that in relation to state and state dispute settlement, that much of it may be behind the door. I think that possibly also applies to trade. I think that trade, certainly as I understand trade is very concerned about having its dirty linen washed in public. And it's one of the reasons that English arbitration has been so popular in trade, is so popular in trade disputes, because English arbitration is both private under the Arbitration Act and also confidential. And the confidentiality doesn't come from the Act, as many people seem to believe, but confidentiality in actual fact is a common law presumption. And that's not insignificant, because a common law presumption can be, being a presumption, overturned, but it has to be very compelling reasons to cause a court to overturn a presumption in any area of law. And certainly the presumption of confidentiality in trade dispute arbitration requires an overriding public policy interest. And certainly there are very few overturnings. And I think that goes back to trade's dislike of what we would call washing its dirty linen in public. And one of the factors of trade, as I understand it, my experience with trade is shipping and international sales and shipping and trade disputes. So the core, really, as I see it, the core of everything else that occurs, because people need to move goods and they need people to move goods, and they need to satisfy economic demands, and there are always economic demands. And trade, it seems to me, in my experience, is based on a good market reputation. And one of the reasons that confidentiality and privacy is so important is that the trade cannot really distinguish between clean linen and dirty linen. So if you're washing linen in public, you're washing linen in public, which gives rise to trade confidence concern. And the overall tenor of my talk this morning is really a question, I think. When I suggested the title, A Settled or Disturbed Landscape, I had a very different view from, I think, the one I have now. And I'm not sure, actually, that there isn't any landscape. So with that, I'll probably make a proper start. This is, as Chiara says, I run a course at Solent University, a very successful private law based on English law, maritime and trade obligations and claims postgraduate course. And this is the fairly new building at Solent University. And this is what is called the Spark Building. And the idea is that Spark Building is supposed to give a spark of inspiration to scholars and students alike. And I have to say, the photo doesn't do it justice. It does give that sense of encouragement and forward looking. And this is a pod which houses lectures and social functions. And so I wonder whether I have or can provide any spark of inspiration this morning. So, well, Chiara has already mentioned this. The Belt and Road initiative was launched in 2017, and it comprises of a Silk Road economic belt and a 21st century maritime road. And it seems to me that the trade dispute and successful growth of trade sort of go hand in hand. And there are always, with any trade venture, challenges and risks. And challenges and risks lead to complex dispute resolution. And it strikes me that in many ways this will engender change. The BRI will engender change because all initiatives, if they are successful, and my belief is that this will be successful. The world has moved on and we are global, and there is a need to promote global trade because no world ever goes back. China is very committed to being part of the global picture, so to speak, and to be in the party. And so I have no doubt that it will be a success. And therefore, whether or not the dispute is complex, and most disputes are complex, they will need, trade certainly needs a fairly swift resolution, and it needs a swift resolution that is generally brought about by experienced arbitrators and lawyers and players in the dispute resolution picture. And one of the things I've considered as I've been drafting up my slides is the extent to which China, with its new dispute resolution forums, one of which the CICC, to which Chiara has referred, I question the extent to which China dispute resolution is sort of up and running with the rest of the world. And certainly here in London, without wanting to be jingoistic, but we rather see ourselves as the center of trade disputes, both in the commercial court and in arbitration. And we see that we somewhat go hand in hand in the sense of importance with Singapore, and then probably Hong Kong sort of trailing, not at all far behind. And trade disputes have been going on ad infinitum. So the question must be, if we're looking at the landscape for BRI disputes, the question must be, to what extent is it going to change? And that seems to me to create a tension between China wanting to promote itself as a global economy, as a global trade center, with, of course, a globally accepted trade resolution center. But trade is already happening. Trade isn't new. The economic belt and 21st century maritime road may be new initiatives, but the concept of trade with China isn't new. The concept of trade in China isn't particularly new. And certainly the concept of world trade, and therefore world trade resolution, isn't new. And so in looking at the landscape of where we're going to go with our disputes, I'm not sure now, having thought about the presentation, whether we are particularly settled or unsettled, or whether we're actually just going to muddle along and the landscape be what it is. And so we have to look at the main aims of trade arbitration. And in actual fact, I would think that state arbitration, state by state, has exactly the same aims. And it's interesting that international commercial arbitration really was engendered by these needs in trade disputes between nations, particularly France and Britain. And so there has to be an element of negotiation. And certainly alternative dispute resolution, it seems to me, gives more scope for negotiation throughout than certainly litigation here in the commercial court does. And there has to be an element of conciliation. And it strikes me that alternative dispute resolution in these two senses is much more appropriate. And much more keeping trade going, keeping your relationships going than litigation is. And then there must be a binding award. And this is a bit of a rub, really, I think, in that we do question, or there have been questions and quite a lot of academic focus on the extent to which the arbitration awards that have come out of China have been considered to be binding. And there is also a knock-on effect of that. Certainly, it seems to me that China is committed to having no appeals binding arbitration awards. Now, we here in London have a sort of an approach to that. The Arbitration Act 1996 certainly tightened up the scope in which the parties could appeal, or one party could appeal from an unwanted arbitration award, because it has been felt, and there are those who would argue that this is right, it has been felt that you agreed to go to arbitration, you agreed to keep the washing of your linen private, and so just because you are dissatisfied with the award, you then shouldn't be allowed excuse me, to go running off to the courts. That is a meritorious philosophy. The problem is that if there is no appeal, no chance of appeal into the court system, it raises the question of, well, who will judge the arbitrators? Now, of course, one can have that with the courts, but on the basis that arbitrators are chosen, and on the basis that, certainly from a lawyer's perspective, arbitrators may well be more trade influenced than legally influenced, the question arises, of course, of what happens if you suspect your arbitrators were biased. But I think more importantly, from a lawyer's perspective, what if the arbitrators are manifestly wrong about the law? And it seems to me BRI or otherwise, and certainly I think in, you know, our early days of BRI disputes and trying to engender confidence, when you enter into your trade relationship and hopefully you choose an applicable law, you do start from the premise that that is the framework which is going to govern any dispute you have, because of course contract law under any jurisdiction, any applicable contract law, is not about the parties getting what they want. It's about providing a framework of dispute resolution, of clarity about obligations. And if the arbitration panel is wrong about the law that is applicable to those obligations, surely it should be in the party's interest that the award is appealed. And this is, you know, a problem. And it seems to me that it may be one that hasn't had enough attention addressed to it yet in the BRI framework of disputes. And then we also have to look at the place of early neutral evaluation. And early neutral evaluation is, as I think most people will know, a sort of a non-arbitration, non-litigation, non-judicial assessment, hopefully in the sense of keeping the parties on track together, moving on from the dispute without taking it any further. And so these are the main aims, it seems to me, of any arbitration, trade or state by state. And it strikes me that the question is, are these aims going to be preserved? Are we going to be satisfied that the aims have been considered in the way we expect, and not necessarily appropriately or more appropriately or less appropriately? I think it's the expectations of trade, most of which are already entrenched. It's the expectations that must be managed. And I was minded of Stein's words when he was in the Court of Appeal in an agency case, First Energy, which seemed to be scuppered the claimant's arguments that the manager from the bank had ostensible authority to agree a loan, which the bank wanted to pull away from because the market rate had changed. The market had dropped down and they were not so confident on getting the return. The First Energy seemed to be scuppered by a House of Lords case called in Amargus. And Lord Justice Stein, as he was, opened his judgment with the words, "It is a feature of the common law that it give effect to the reasonable expectation of honest commercial men." And it strikes me that that is the bedrock of arbitration, that it does give effect to the reasonable expectations of commercial men, because those reasonable expectations are based on what they expect, or what they now think they expected from their trade relationship. And those reasonable expectations, and of course one can always question the concept of reasonableness, but they are really based on a cultural awareness, and they can be derailed by conflicting jurisprudence. And in my experience, one of the difficulties of trade disputes is this conflicting jurisprudence, which in relation to BRI disputes seems to me to be an enormous problem, that it'll be a while before we get over tensions between expectations of jurisprudence in China and expectations of jurisprudence, say, in Asia, and particularly in Europe. And managing disputes on the face of it, well, on the face of it, the critical issues are a choice of law which suits the parties and a choice of arbitration jurisdiction. Because the maxim is, when in Rome, you arbitrate as the Romans. Now, one of the problems, particularly in an emerging area of trade, is that when the contract is fixed, so when the contract is formed, and when the parties are settling their obligations and choosing their applicable law, and choosing where they will conduct the arbitration. It seems to me that these considerations are always driven by getting what they want from the bargain and about negotiating in a spirit of bonhomie. The problem, it strikes me, and this has long struck me, the problem, it strikes me, is that once the unhappy day of dispute arises, parties can fundamentally change their minds on now what they want. Now, the whole aim of a choice of law clause, a choice of arbitration or the jurisdiction litigation form is to reduce or at least minimize the time and money spent on shifting around from that. But given the amount of litigation that occurs on the one party now reneging on a choice of law or a choice of jurisdiction clause, these must be serious concerns. And I can't think that this is going to change. The element that drives a predominant amount of trade, hardcore shipping and international sales disputes, the element which really drives them is a change in the market rate. The market rate drops against one party, and he now wishes he weren't in the contract, and he's looking to see if he can suggest that a breach by the other allows him to walk away. And it's this change in the market rate, a change of perception about what you want, that seems to me to be a very dangerous thing. And if we're looking at managing the dispute and minimizing risks, then we have to ask, as I've referred to earlier, what is trade familiar with? It's a key issue. The entities trading out of China will not generally be brand new entities. There will be some new entities, some new trade, but a majority, many of them will be familiar with trade and trade dispute resolutions. What are they familiar with? Well, English law is a predominant choice. The Arbitration Act is a predominant choice. And we might question why that is. Are people going to be more encouraged to use systems in China, to use the courts and arbitration set in China, or are they going to be concerned and nervous about them? Certainly here, the requirements of privacy, confidentiality are very entrenched in trade. But on reading around, it seems to me that this may be in conflict with the transparency required in Chinese-related mediation and arbitration. And so we have a tension which gives rise to a hugely unsettled forum and landscape. The essentials for arbitration, for successful arbitration, are the successful enforcement of an award. And it cannot be that anyone goes to arbitration other than to get the award. It's not your day to lament about the dispute. Parties who want to lament about the dispute, to find a common ground, are much more advised to go to mediation. Arbitration is a dispute settlement. It is a disagreement, just as litigation is. And therefore, the one reason you are going is to get your damages, so to speak, to get your money. And therefore, the successful enforcement of an award is absolutely critical. And it's one of, I think, the main reasons for going to arbitration. Certainly, I think the two, as far as English law are concerned, are privacy and confidentiality, which of course are not part of all arbitrations. But the other feature, which is a part of all arbitrations, is an ability to enforce the award. Much more possible and much more easily done in a foreign jurisdiction than the enforcement of a foreign judgment. And therefore, it must be that BRI disputes in the People's Republic of China must be seen to have a willingness to embrace the New York Convention. And there must be an internationally accepted approach to the enforcement of awards and reservations under the Convention. Now, there isn't in the last 10 years a huge amount of jurisprudence. The jurisprudence that is around seems to be mixed confidence. It strikes me that, of course, newly formed resolution dispute centres will need to get up and running. And that's the point I made at the beginning, is will that engender confidence, or will people in trade, wherever they're from, BRI or otherwise, lean in towards a more established means of dispute settlement? And so this, to me, seems to be part of a very unsettled landscape, this issue of successful enforcement of awards. But it may be that there is a leaning in by the Chinese dispute settlement forums. They have been newly set up. They wouldn't have been newly set up to stand alone and be outside the mainframe of thinking. So I think that in a way, we are an unsettled landscape, but with a view to more certainty of it being settled. And Chiara mentioned some of these. She mentioned the International Commercial Court of China, the Chinese International Commercial Court, but these are the main either established or hopefully moving forward to be established dispute forums. So there's the International Court of Arbitration under the ICC, which has been immensely successful. So it hears dispute resolution from the American Arbitration Association, the London Court of Arbitration, the International Chamber of Commerce, and they are already immensely successful. And the International Court of Arbitration has centers around the world, and this is established, well-respected forum for well-respected arbitration dispute settlement. There is the Beijing Center, which was set up in 1985, Hong Kong Arbitration Center, 1985, and the China-Africa Joint Arbitration Center for that part of the BRI venture, set up in 2015. Then there is the International Court of China, which was set up in 2018, and the International Commercial Dispute Prevention and Settlement Organization set up in 2019, which is in cooperation with the China Chamber of International Commerce. And although these are new, and although there have been, and the discussion around them highlights, as it would, the teething problems, it seems to me that these are a positive flag for the future. And the settled landscape, yes, must come from established International Court of Arbitration type arbitration. But no landscape ever became settled without being newly forged and therefore unsettled to start with. And so I think when we look at these centres, we should have a sense of positive forward looking. And I think that we will come back in 10 years' time and be more confident about the landscape on which these centres are established and which they are establishing being settled. And then I think, and I realize I'm coming to the end, I've come to the end of my time. So I think it's worth mentioning just a couple of points about the China International Court, Commercial Court. It seems to me that the general view of this is gaining credibility. Any international arbitration forum must have international credibility. But it strikes me that in the People's Republic of China, there's more than awareness that they do not sit in an autonomous vacuum now, particularly if they want to promote economic success under the BRI. And the Shenzhen Court, there are two courts set up under the CICC, and the Shenzhen Court of Arbitration had a very successful training program. And it could be perceived as a catch-up a catch-up way of gaining skills, way of thinking that the more established arbitration forums are with already. Team of visiting lawyers has went out, and visiting lawyers has been become a feature. Surely this must be a good thing. If you Google PRI ADR dispute resolution, the international law firms, the big established, which we think of as the London city law firms, but which are the international law firms, all have firm presences, a firm presence in China. All are promoting ADR dispute resolution in China. This surely must lead to a more settled, successful landscape in China. There's an opening up of foreign legal services in the People's Republic of China. It strikes me that this is a game changer. It's established for international trade disputes, and it's truly innovative. And in looking at its innovation, we should remember that actually China always saw, long before it became the People's Republic of China, it always saw itself as a nation of conciliation and mediation. And it is aiming, the court is aiming to provide a one-stop shop for dispute resolutions. Decisions are final and binding on the parties, which might in some ways cause concern because there's no redress. But then wherever you are, there comes a point where there is no redress from a decision or a judgment with which you are unhappy. And a one-stop shop, which the court is promoting, certainly will engender, if the court is successful, impartial, open-minded, a willingness to embrace an accepted international jurisprudence. It strikes me that this will be a settled landscape. And so to conclude, can we predict anything at this stage? And I think, yes, we can. When I started the presentation, when I started thinking about it, I thought, no, we couldn't. But actually, I feel more positive. I've read quite a bit of academic debate on the matter. And generally, I'm not so sure that I'm over-influenced by academic debate. But I think I am in this sense. I think that to a certain extent, we have more academic debate than anything else, and it will cause lawyers to reflect. And I think arbitration is important. It's hugely important to support China's initiative. And I think China will support arbitration dispute resolution. There are difficulties, but there have been positive changes. And all of the debate shows that there have been successful rates and enforcement of awards since 2011. And so I think it's watch this space. I think we are, to conclude, in unsettled territory, but I think we move towards a much more settled landscape, which will be advantageous to all. And thank you very much. Thank you very much for listening.
Thank you, Susan. Thank you very much. It has been a very, very interesting presentation. I thank you for having underlined the great importance of arbitration for the success of the PRIN initiative and the many reasons for sustaining this position. I share this view, and thank you also for having explained so well how important is the experience, for instance, of the English international trade arbitration as a source of inspiration, as well as for the international arbitral jurisprudence for this new experience in arbitration. China is looking for also as a host country. So thank you again. So since PRIN initiative involves huge investments for the creation of sea routes that will connect China to the markets in the rest of the world, a key role in arbitrations, such as those provided at the European level by the arbitration chambers in Paris, Hamburg, and Copenhagen. And this topic will be examined by Professor Philippe Delbecq, who is full professor at the University of Panthéon-Sorbonne, Paris, and president of the Maritime Arbitration Chamber in Paris. Professor Delbecq will present a talk entitled The International Maritime Arbitration in the European Union. Merci beaucoup, Philippe. Je suis ravie que tu as accepté notre invitation. Please, Philippe, the floor is yours.
Thank you, Chiara, thank you for your invitation. I am very happy to meet you again and to be with you and other colleagues. So I'm going to speak about maritime arbitration in the European Union. Yes, please. As you know, maritime arbitration is a very usual settlement in maritime affairs. It is very common. This kind of arbitration is often institutional arbitration, and principal chambers are, of course, London Maritime Arbitration Association, LMMA, Paris, Chambre arbitrale maritime de Paris, Hamburg, and Copenhagen with Danish Institute of Arbitration. Ad hoc arbitration is less important, but sometimes used. Maritime arbitration is sometimes an instrument of settlement. Go to arbitration, discuss, and after that to settle and to find an agreement with the parties. But of course, maritime arbitration is principally a method of settling disputes. The arbitrator is a judge, a private judge, but a judge. Most of the time, maritime contracts include arbitration clauses. That is the case in salvage contracts, shipbuilding contracts, agency contracts, sale of goods, of course, carriage of goods, and affrètement in French, that is in English, charter parties. Voyage charter, time charter, or other bareboat charter. Is there a specificity to arbitration in European Union? That is the question I have to answer. Next, please. I think that balance of interests is an essential requirement in European Union. First, an essential requirement as for choice of arbitration tribunal. We know that there are different chambers, as I told you, competence in maritime arbitration are London, New York, Hong Kong, Hamburg, Milano, and Paris, and so on. But the sensitivities in those chambers are not exactly the same. London is an excellent place of arbitration, of course, but London is quite more expensive than Paris or Hamburg. And this cost may discourage some shippers or other industry. Going to Paris or London is not neutral, either as to the law applicable, but the differences in this area should not be exaggerated. There are, of course, law, but few differences concerning substantive law. And in arbitration, the most important thing is to consider first first of all, the contract binding the parties. Next. Nevertheless, the requirements of balance of interest is more essential in Europe than in other countries. The question of balancing interests arises under maritime contract and trade contract, carriage of goods, affrètement, charter party, insurance. It is certain that ship owners are more protected in London than elsewhere. It is not the case in Paris or in Hamburg, where the cargo interests are always taken into consideration. In any case, the same questions arise before a tribunal in London or in Paris. Some are classical, like cargo claims, anti-business, the validity of and the application of liberties clause in affrètement, freight, the payment of freight, lien, droit de rétention, letter of undertaking, or demurrage. Other issues are recent, like hardship clauses, safe speed clause, anti-corruption clause, piracy, or for the moment, it is very important to understand the green clause and to apply in affrètement, in charter parties, the green clause. I will say a few words below about the issues that arise in carriage contracts, in charter party, and insurance. First of all, carriage contract. We don't speak about a liner contract, about a liner bill of lading, because in liner bill of lading, we do not find arbitration clause. In liner bill of lading, we find state jurisdiction clause. And by example, CMA, the French company, CMA, bill of lading provides that the competent tribunal is Marseille and not an arbitral tribunal. The context is quite different under charter parties and under bill of lading to be used with charter party, where we find arbitration clause by reference to charter party. And there are relations between owner who has issued bill of lading and the holder of bill of lading or the endorser of bill of lading. First issue, what about the arbitration clause? This arbitration clause is certainly valid, but not necessarily opposable to the holder. It is opposable to the holder if this holder has the possibility to know the charter party. Second question, what about anti-suit injunction? If the question is this one, if the holder considers the holder of the bill of lading issued with under charter party, if the holder considers that the clause is not opposable to him, the owner of the ship which has issued this bill of lading sometimes obtains by the courts in England an anti-suit injunction. The injunction is this one, in substance. If you do not go to arbitration, it is a jail, it is a contempt of court. In European Union, Court of Justice has considered that this injunction, this anti-suit injunction, is unacceptable. But after the Brexit, anti-suit injunctions are again practiced. from my point of view, it is non-acceptable. What about applicable rules? The Bill of Lading refers generally to Hague rules, Hague-Visby rules, and sometimes contain a paramount clause, a clause that say which law is applicable. This clause is perfectly valid, and there is no dispute about this kind of clause now. Considering carrier's liability, this liability is often under discussion before a tribunal, an arbitration tribunal. We applied the classical system of liability. Liability if there are damage, liability is engaged, and there is possibility for the carrier to to prove an accepted case, and the holder of the BL has the possibility to neutralize this accepted case by proving the fault of carriers. There are many awards on this kind of liability, on the system of liability. About adjective law, we find always the issue of time limits and, of course, of notices. Next. There are some specific issues before arbitration tribunal in maritime areas. About free in-out clause. The question is this one. It is possible for a carrier to precise that he is not liable for loading or disloading. I am not sure of that if Hague-Visby rules apply under this bill of lading. As for carrier's liability, we discuss often about accepted clause, nautical and especially about nautical fault, how to conceive nautical fault, this kind of accepted case, narrowly or largely. From my point of view, we have to conceive this very specific accepted case narrowly. Another issue concerns the surveys and how to consider unilateral surveys. It is very often now for the party to design, to organize unilateral surveys. It is possible, but it is only an element of proof. Another question concerns compensation in bulk carriage. The question is this one. How to consider the term unit to fix the limits of liability? How to consider the term unit used in Hague-Visby rules? Does it refer to a unit of measurement or to a physical wall? Under French law, we consider the term of unit like a unit of measurement, but under English law, in bulk carriage, the term unit is considered as a physical wall. The reference is Aquasia case, a very famous case concerning fish oil in bulk. Other question, or of course, a very common question concern the subrogation of insurance. But now the case law is fixed. We are waiting, of course, now in maritime community, waiting for the Rotterdam rules, the new convention, not ratified, but source of inspiration. And one of the goals of Rotterdam rules is balance of interest. Shippers' interests are considered because carrier has to make the ship seaworthy during the voyage and not only before the voyage. Nautical fault is deleted and the compensation is higher than in Hague-Visby rules. Carriers' interests are considered. Duties and liability of the shipper are envisaged, and freedom of contract is admitted in services. About charter party, about affrètement. The first type of affrètement charter party is voyage charter. It is a contract between an owner and charterer. And in this kind of contract, nautical and commercial operations are assumed by the owner of the ship. And we speak about freight and not hire. And the charterer has to pay freight, and the cargo is mentioned under the charter party. We find a recurrent issue between owner and charterer concerning lay days, demurrage, notice of readiness, and expected time of arrival. The problem principally concerns the interpretation of the clause of charter party. And the important thing is to know when the ship has arrived in the port, so that we can count the lay days. And it is a very, very interesting problem to know how the ship is arrived in the port. I have supervised a thesis on this subject. The title of the thesis is the arrival ship. I think it is very, very interesting. About time charter. Time charter, as you know, is a contract between an owner of a ship and a charterer during time 6 months or 2 years, by example. In this time of contract, nautical operations are assumed by the owner, but commercial operations are assumed by the charterer. As for relation between owner and charterer, usual disputes concern off-hire clause and safe port clause. An Eastern City case, the famous Eastern City case, is a leading case. Is a reference in maritime law. If I may, I recall you this jurisprudence, this case law about safe port clause. A port will not be safe unless, in the relevant period of time, a particular ship can reach it, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. It is a very famous jurisprudence and admitted, of course, before a French tribunal. As for relation between parties and third parties, the bill of lading holder, between third party and time charterer, there is a contractual relation, but between third party and owner of the ship, the principle is that there is no contractual relation. So the liability, if any, is extra-contractual, but it is often a matter of discussion before an arbitral tribunal in Paris. Next, other treatment, other charter parties. First question concerns a trip charter, a time charter for a trip. How to consider this kind of contract? A time charter of a voyage charter. I think accurate qualification is time charter, but it is in discussion. About slot charter, a new contract. It is a new kind of contract. By example, CMA, a French company, CMA CGM, rents slots under a Maersk ship or a MSC ship, and vice versa. It is a slot charter used by a company, a maritime company, to have a quantity of transportation, a capacity of transportation. As for relation between parties, between the owner and the charterer, the principle is freedom of contract. As for relation between third party and bill of lading issuer, carriage of law does apply. Next, the third contract, very often applied before tribunal, arbitration tribunal. Balance of interest between insurer and insured is always an essential feature in European law and before an arbitration tribunal. As for assurance corps, ship insurance, and assurance faculté, commodities insurance. The law is different. Under civil law, the system is the system of abstract exclusions of guarantee. Under common law system, we find exclusion limited, and the system is an enumerated exclusion of insurance. Another issue is the relation between third party and liability insurer, PNI club, as you know. Under civil law system, direct action is admitted. And the question is this one: may arbitration clauses be circumvented in direct action claims under civil legislation? There is a very big discussion about that. And a recent decision of Court of Justice in European Union in steamship case has, for the first time, said no. Under common law system, the rule is different. The rule is pay to be paid. And as you know, the direct action is not admitted. My conclusion for this moment, once again, the requirement of balance of interest is important, very important under civil law system. We reach this requirement by the law, by the contract, and by arbitration. Last word, we have to consider the contract and parties' will, the fundamental rule under maritime arbitration, under French law, civil law, and under common law is, and the common view is a contract first. Thank you for attention. I have cite some awards for your interest, and I think you could read after my presentation those abstract. Thank you again very much. Thank you very much.
Thank you very much.
My English is not very good.
No, it was absolutely clear. Thank you very much, Filippo, also for this abstract and for your very comprehensive presentation. Professor Del Becque has given us an overview of the vast number of considerations regarding maritime arbitration, which can be utilized not only for maritime carriage or charter party contract disputes, but also for international sale and insurance contracts disputes. Professor Del Becque has also emphasized the consequences in terms of balancing the interests involved arising from the different approaches adopted by civil law and by common law systems. Therefore, adequate attention must be devoted to the choice not only of the national law applicable to the contract, but also to the indication of the place of arbitration. Indeed, I think that maritime arbitration, as has been managed by London, Paris, Hamburg, and Copenhagen chambers, is a very important traditional instrument to settle international trade disputes under the law, or to be more precise, under the rule of law. To quote Professor Del Becque, the arbitrator is a judge, even though a private one. And I think that this vast, important experience and expertise cannot be ignored by new arbitral forums for the success of the international trade dispute settlement. So thank you again, Philippe.
Thank you, Chiara. Thank you.
And now it's time to give the floor to Professor Elena Zucconi Galli Fonseca. Elena is full professor of civil procedural law at the Department of Legal Studies at the University of Bologna, and will present a talk entitled Arbitration and Interim Measures, the New Italian Regime. Please, Elena, the floor is yours.
Thank you very much, Chiara. Thank you, Elena, for having invited me. I try to share my PowerPoint. Let's try. So this is okay. Perfect. I hope that you see. You see the lights in an entire video?
Yes. Very
okay,
well.
fine.
Thank you.
Perfect. So I will try to present a new choice, a very important choice that our legislator, Italian legislator, has made with the recent reform of our procedure. And this is the choice to grant interim powers to arbitrators. It's the first time that in Italy this is possible, and I think that it must be underlined in order to invite all the investors all over the world to come and litigate in our country. So let's see how is the new system. This is the scheme. The rules that contains the discipline are in our civil procedure code, and 3 rules for interim measures, and one specific rule for a specific measure which is the stay of resolutions by shareholders meetings in company law. This is very important because arbitration here in Italy is very used in company law. So the key rule is this one. So you see before Article 818 ruled that arbitrators could not grant conservatory seizure for security. We mean Mariva injunction, as to intend. may not grant conservatory or other interim relief measures, except if otherwise provided by the law. There was only a case, that was the stay of resolutions, as I said before, in company law. But now things have changed. Article 818 now says that the parties, including by reference to arbitration rules, may grant the arbitrators the power to order interim relief measures by the arbitration agreement or by a written document prior to the beginning of the arbitration proceedings. The interim jurisdiction granted is exclusive, though I underline this characteristic because we'll talk about later. And prior to the acceptance of the sole arbitration of the establishment, we should intend constitution of the arbitration tribunal, the request for interim relief shall be proposed to the competent court. And there is a reference to the rules of interim measures granted by the courts. So, if we would like to make a scheme of this article, we would see that powers to the arbitrators are granted only by will of the parties. And the will of the parties can be expressed also by reference to institutional rules. And this is the most interesting solution and most frequent, we think, choice, because it's rare that the parties provide specifically for one feature of the arbitration in the arbitral convention. Exclusive powers after acceptance by the arbitrator. And this is very interesting because other states have made a different choice. The UNCITRAL model law provides for a concurrent jurisdiction in interim measure powers between arbitrator and judge. For us, it's a neat choice. After acceptance, the powers of the arbitrators are exclusive. An appeal is granted pursuant to Article 818 ter, we'll see it. And implementation is made by the judge. It's a judge affair. Before acceptance by the arbitrator, and a fortiori before the beginning of the arbitration process, the power is given to the judge. And this is a problem. So if we want to make a synthesis, we'll say that before the request for arbitration is served, the request of arbitration is the first moment of the arbitration process. And after the serving of the request for arbitration, but before the acceptance of the sole arbitrators or the acceptance of the last arbitrator in the tribunal, the judge has the power. The judge who would have had jurisdiction on the merits, this is the criteria that is used to identify the right judge. After the acceptance, the arbitrator has the power. Two questions. What if the interim measure is intended to have effects beyond the parties? This is a problem because we said that the interim measure must be granted by the arbitrator after the acceptance. The jurisdiction is exclusive, we said. But what about the case in which we have an interim measure which has effects beyond for third parties? let's think about a guarantee, a third-party guarantee. So I think that in this case, arbitrators can't have jurisdiction. So we'll have to fight the judge, apply to the judge. And the other very important question for international arbitration, because here we're talking about especially international arbitration, is the problem of the emergency arbitrator, which is a very important institution in international arbitration, because parties don't want to apply the judge. Let's think about this very interesting rule, which has been introduced in the Milan Chamber of Arbitration Rules, the most important institution in international arbitration in Italy. And there it is provided that, unless otherwise agreed by the parties, any party prior to the constitution of the arbitral tribunal, any party may file an application in order to obtain an interim measure by the appointment of a sole emergency arbitrator. Is an arbitrator which is dedicated to this preliminary phase. And we must make a question. Is it possible now to use this particular means of obtaining an interim measure, as we have said that the law provides for an exclusiveness only after the acceptance? We haven't an arbitral tribunal yet. I think that this must be granted. So I think that the parties can provide expressly for an emergency arbitrator. And in this case, the parties have given the arbitrators the power to pronounce interim measures, even if in this case, it's not the arbitrators on the merits, but a sole arbitrator dedicated to this kind of order. So I think that this is possible also after the reform, but it is discussed. The scholars are discussing. I think that it's very important to grant it, as international arbitration needs emergency arbitrator and international arbitration. Let's come to the appeal. We said that the interim measure can be appealed before the court. Article 818 bis provides that an appeal against the order of the arbitrators granting or rejecting an interim measure may be filed under Article 669 terdecies. It is the rule about appeal against the court order. The appeal is treated by the Court of Appeal in whose district the seat of arbitration is located. We need to know what is the seat of arbitration. On the grounds set forth in the first paragraph of Article 829. What are these grounds? They are the same grounds for the award, for appealing the award. Insofar as compatible, the compatibility is a hard exam. We don't have time to go into this problem. And on the grounds of contrariety to public policy. Let's go through this rule. First of all, we said that it's only possible to set aside the interim order before the court if there are some errors in procedendo, some procedure mistakes. For example, the parties didn't give arbitrators the power to order interim measures. Or right of defense was not respected. A specific problem about it is on the preliminary order inaudita altera parte. But if new circumstances arise, let's think, for example, to new circumstances that arise while the term for appeal has not yet expired. Can we ask the court to go into the merits of the interim measure when new circumstances has arisen? So this is a very debated topic. I think that the rule forbids the court to enter, to pronounce, to order the merits of the interim measure. So I think that it's not possible to ask the court to pronounce the measure on the merits. We have to ask the arbitrators to give a new order. What about the case in which the arbitrators have rejected the request? Can it be reiterated? I think yes. But I think that a specific rule applies dedicated to interim measure before the courts. And this rule provides that the request can be reiterated only if new circumstances arise, unless the request was rejected on the ground of lack of jurisdiction. Another question. If the judge grants the appeal when the arbitrator has rejected the request, can the judge pronounce the order, decide on the merits of the request? And the answer is, I think, no, for the same reason that we saw before. Specific rules, I said, about the validity of meetings resolution in company law. The difference is that arbitrators have the natural power to pronounce this kind of measures. There's no need for the parties to give expressly this power. And also in this case, the power is subject to appeal. The measure can be appealed. The rejection of or the granting of the measure can be appealed before the courts. This slide gives me the occasion to say some words about the meaning of the interim measure, because this is a problem in the international panorama. There's a big discussion about the meaning of interim measures. When they talk about the Italian system, we must recall that for interim measure, we mean anticipatory measures and conservatory measures. For example, the UNCITRAL model law is a little bit restricted about it. We mean, for example, preserving the assets or maintaining the status quo. This is the typical conservatory measure. Or the measure that anticipates the effects of the final award. This is what we call urgence measure, provvedimento d'urgenza. But, for example, we cannot include the security for costs. That is a very frequent preliminary measure in English law, for example. And also the anti-suit injunction that was about which the present colleague talked about. The anti-suit injunction is not permitted. Said that, let's come to the implementation. The implementation, as I said, is granted of the interim measure granted by arbitrators, is governed by Article 669 duodecim, which means that is carried out under the control of the court. And this is very important because if I ask, is there a need for an exequatur of the measure pronounced by Italian arbitrators, I answer no. And this is a very hard choice because, for example, the UNCITRAL model law provides for a recognition and an enforcement of the measure before the courts. This is not the choice made by the Italian reform. The measure is automatically, directly executive. There is the appeal, but an exequatur is not requested. And the same solution applies to the foreign interim measure. And this is very interesting. We don't provide for an enforcement of the foreign interim measure, which is implemented by the state court at the same condition we saw before, according to this rule. This is a very debated, discussed point, let's say, because it seems very hard to accept without a control a foreign interim measure, but it's also very interesting for the investors all over the world. Some scholars think that the New York Convention must be applied, but the New York Convention talks about an award, which could be also an interim award. It is discussed, but the interim measure is not pronounced by the arbitrators with an award, but with a different kind of pronouncement, which is an order. So it's doubtful that an order must be enforced according to the New York Convention. I come to the end, remembering that our system provides for a special discipline about the anticipatory interim measures. What means that when the measure anticipates the effects of the award, I said we have a special regime, and the special regime consists in no obligation to begin the process on the merits. When we have asked the measure, when we have requested the measure before the court, before the beginning of the arbitration proceedings, and we obtain the order from the court, we have no obligation to begin the process on the merits, the winning party. But it's the losing party who have to begin the arbitration if she wants to terminate the order, the interim order. And also, if the arbitration on the merits is terminated, the measure is terminated before the award, of course, the measure survives. This is a very interesting feature of our system. So thank you very much. I'm in the end, and if some questions are also accepted, I am here to answer at the end of the seminar. Thank you.
Thank you, Elena, for your very interesting presentation and the information you gave us about the arbitral interim measures that may affect also cross-border disputes, as they have been introduced by the recent reform of Italian civil procedural law. I wish to draw your attention to the focus Professor Zucconi made on the issue of emergency arbitrator, as it has been regulated also by the Milan Arbitral Chamber, and the implementation of foreign interim measures, as well as the role that might be played by the Italian courts regarding appeals against arbitral interim measures and their enforcement. I think we can conclude that also in Italy, we are highly experienced arbitral chambers and institutions that can successfully contribute to the settlement of international trade disputes like those related to BRI. So, since e-commerce is an ever-growing phenomenon, which is likely to grow also as a result of the PRIN initiative, attention should be paid as well to the internal complaint handling systems adopted by online platforms. And for this reason, I'm happy to welcome Ms. Angela Felicetti, who is a PhD student in legal studies at the University of Bologna and member of the Bologna Bar. Angela will talk to us about justice on e-commerce platforms. It's a question. The cases of Amazon and Alibaba Group's platforms with a focus on platform to business disputes resolution procedures. So please, Angela, the floor is yours.
Thank you so much, Professor Alvisi. Thank you and Professor Elena Orru for having me. Can you hear me and see my screen? Okay, thank you so much. From the previous presentation, we heard in a very clear manner how the PRI project is actually creating a need for effective dispute settlement mechanisms. And I will also focus on private actors, disputes, and on alternative to national courts. So we heard about actually arbitration mostly. Professor Oker also mentioned commercial courts, which are of course embedded into the national legal system in some instances. And we know from the literature that there are also some mediation initiatives which have been implemented within the framework of the BRI. Now, in this already very complex framework, I would like to add a further element of complexity by considering e-commerce dispute resolution. And here I come to a very simple and straightforward question. Are these procedural mechanisms that we mentioned appropriate for most of e-commerce disputes? Well, the answer is pretty straightforward. They are not. They're maybe too complicated or too costly for parties to record to arbitration or similar means. So I argue that it could be useful to also include e-commerce appropriate dispute resolution mechanism in our discussions, since we know that the promotion of Chinese cross-border e-commerce to the international market is one of the collateral points of the Belt and Road Initiative. Now, in order to set the grounds for my short presentation, I should probably first introduce you to the digital platform model. Let me share my screen in a bigger way. There we go. So, of course, we all know that platforms are key players in the digital economy. Also, the economic literature uses the term platform economy. And in the e-commerce sector, platforms are the prominent organizational model. So what is a digital platform from a legal point of view? Here I try to provide you with some visual representation of this very complex phenomenon. From a legal point of view, platform is a centralized scheme based on a bundle of contracts. You see at the very top, at the center, we have a platform operator, which is a business that is carry out the fundamental task of managing the platform digital infrastructure. And then we have a community of users that join the platform to carry out various activities. In case of e-commerce, of course, it's economic activities we are looking at. So users, consumer wishing to access to market, and commercial users as well, businesses wishing to sell their products to the online market. Now, I said that the platform acts an intermediary in this framework, and its structure is based on a combination of contract. The most important one is a term and condition agreement, which is the contract that each user has to enter into in order to be able to carry out activities on the platform. And this term and condition very or a professional. Now, we also have other kinds of contracts. We have policies which basically contain rule of conducts for users. And we also have, of course, like direct contract between commercial user and consumers. Now, in this framework, dispute resolution mechanisms are an integral part of the platform structure. They operate both when a dispute arises between two categories of users. So we have a merchant on one side and a consumers on the others. But they also operate dispute resolution mechanisms when we have a conflict between one of the users and the platform itself. And these conflicts more often than ever concern the breach of one of the provision in the terms of condition or in the policy rules, or some violations of the contract between two kind of users, or the contract that we can have between the merchant and the buyer. Whenever a dispute arises, parties rely on internal system that the platform provides for the management of their disputes. And actually, in e-commerce dispute, internal system acts as a sort of first aid mechanisms for disputes. And the platform is actually a non-neutral manager of these disputes, and it has the capability to impose on the party its own internal procedure. So it may be useful once again to have a visual representation since dispute resolution procedure manifests on various levels, and they often, to some degree, very much lack transparency. Yet they are very important, undeniably important in the lives of consumers and business online. To give you an overview of this complexity, we have several layers in what I call platform dispute resolution. So at the very bottom, we have dispute prevention system, which are embedded in the digital infrastructure of the platform. They are at work constantly trying to prevent dispute from arising in the first place. Then we move forward to complaint handling mechanisms, which are mechanisms that we all have experienced at least once in our life. So it's customer service, it's resolution centers of various sorts. And then we have some more complex mechanisms, such as content moderation. Content moderation entails a constant supervision on the compliance of the content shared by the users with the platform terms and conditions and policies. And particularly in the e-commerce sector, we see content moderation happen with regard to false product review, which are detected by the platform and very often removed. Then we have report systems, which are an additional layer, another common feature in some types of platform, not so much in e-commerce. In any way, in this system, we have users which actually assist the platform operator to detect contractual infringement. And then lastly, in some cases, we have platforms that recur to external providers of online dispute resolution services. And this is done in order to provide user with a sense of impartiality of the third-party operator, and ultimately to it's a way to incentivize users in recurring to these mechanisms. Now, all these different layers concur in platform dispute resolution, and given the complexity and also the diversified nature of e-commerce dispute, I will try to focus for the rest of my presentation on the mechanism that operate whenever a dispute arises between a platform and a business. As I believe, as I mentioned, that this mechanism may be relevant in our discussion around dispute resolution and the PRI. So, of course, we all know that digital platforms offer to businesses an extraordinary opportunity to access cross-border market in a very much facilitated way than the traditional way of access to the market. However, platform operators maintain a very high degree of control over the activities that the users perform within the platform infrastructure. And they are therefore especially powerful intermediaries. In some instances, by taking advantage of their position, of their power position, they may implement unfair contract or trading practices that result in harm for businesses. We have many examples of these, just to mention a few of the most frequently detected harmful practices. We observe, for example, the listing of a product or of a seller altogether from the platform without express justification. We have also sudden changes in the term and condition provision that may require the business to adapt very fast to a new provision. We also have a very complex and fascinating issue that is the one of the monopoly over crucial market data that the platform has and is not so willing, of course, to share with businesses that are operating on the platform itself. So in light of this very complex scenario, a few years ago, the EU regulator decided to intervene to foster fairness and transparency in relationship between platforms, which are hereby referred to as online intermediary, and business users. Now, among many lines of intervention that this regulation 1150 of 2019 undertakes, there is Article 11 that you see some part of it on my screen. Article 11 focuses on platform dispute resolution by mandating some requirements for internal complaint handling systems. Article 11 prescribes that mechanisms that manage businesses' complaint on the platform should be easily accessible. They should be free of charge. They should provide businesses with a quick response, and they should apply equal treatment. Therefore, there should be no discrimination between different businesses. I would argue that the main principle that the regulation tries to enforce is indeed that of transparency. And you see here paragraph 3 and 4 of this provision. Transparency is relevant under a twofold perspective. First of all, platforms should make public information on how their internal complaint handling system works, and they should do so in their own term and condition. And also, platforms should make public data on the effectiveness of this mechanism in resolving issues. Now, the regulation also provides for a second layer of platform dispute resolution that that fall within the scope of the regulation should implement in their infrastructure. That is to say, if the internal complaint mechanism fails in handling the dispute, then business should have the opportunity to engage in a mediation procedure with the platform. And this is what is mandated by Article 12, that essentially tries to bind platforms with an obligation to select potential mediation providers in their terms and conditions, and also bind platform with a duty of good faith during such procedure. Now, the provision also contains a summary description of the main feature of this P2B mediation, and these features are actually nothing less than an adaptation to the new digital reality of those principles that the EU law already mandate with the 2008 mediation directive. Now, just quickly, we run through this feature. So according to the regulation platform to business, mediation is conducted by impartial and independent mediators, of course. It entails limited costs for businesses, is conducted in the language of the term and condition. It's easily accessible, also thanks to the use of remote proceedings. It's a quick procedure and is lastly conducted by mediators who are sufficiently competent in B2B relations and dispute resolution. Now, these features that I just summarized for you are actually very broad. To the point, one could say, of being almost vague. Therefore, we need to look at the current practices adopted by platform in order to understand what platform to business mediation should be. So here I come to my first case study, which concerns Amazon. Of course, Amazon is an e-commerce platform that requires no introduction, and Amazon has a very complex internal complaint handling system for both seller and buyers disputes. It's an extremely complex machinery, and I certainly do not have the time now to discuss it with you. So let me just focus on what Amazon did in respect to Article 12, therefore mediation between platform and sellers. Now, Amazon actually activated a mediation scheme through a third-party ADR provider. And this is the Center for Efficient Dispute Resolution based in London. Well, if we analyze deeply the rules that govern this Amazon mediation scheme, which are published on the CEDR website, we can point out several criticalities related to how mediation is practically implemented. So first of all, there is a substantial barrier to accessibility to the procedure. And this is pretty straightforward. Businesses can initiate mediation if and only if Amazon provides them with an access code Therefore, there is a very obvious barrier there. Also, the scope of the scheme is significantly limited by several rules that exclude various categories of disputes. We don't have the time here to go into too much detail, but basically, essentially, the CEDR administration decides if a dispute falls under the scope of the scheme based on rules which are drafted in a very broad way, with a language that is quite difficult to interpret, and we may actually run the risk of having a lot of disputes excluded from the scope. And finally, and most importantly, I believe, the scheme fundamentally distorts the collaborative nature of mediation by transforming it into a sort of adjudicative procedure, yet with no binding value upon Amazon. Therefore, the mediator it does not actually facilitate the dialogue between the parties, which is actually the essence of the mediation. He or she, the mediator, provides just a solution that yet is just a suggestion for the platform. Now, in light of mediation schemes such as Amazon's, the concern that the EU regulation raised on the fairness in the relationship between businesses and platform, I think, are not yet overcome in Europe. Now, if we have a brief look at China, I think identical concern with regard to P2B relation apply to the Chinese platform ecosystem. Yet, in several respects, e-commerce in China is extremely more developed than in Europe and the US. So, more or less, platform dispute resolution works according to the same parameters that we have already seen. A peculiarity that is, to me, is worth mentioning is that of crowdsourced adjudication, which is very successful in some Chinese platforms, especially in e-commerce disputes. Crowdsourced adjudication is when disputes are decided by a jury of users who are representative both of buyers and sellers. So most notably, crowdsourced adjudication was adopted in 2013 by Taobao. Taobao is basically the most important platform of the Alibaba group that combines the marketplace model with the social network feature in order to connect, intermediate buyers and sellers. Sellers, which on Taobao are small businesses or private individual. Now, Taobao Crowd Jury has been promoted with a famous slogan, "Let collective intelligence shine through," and it is reported to be an extremely successful means of dispute resolution. Now I would like to address in the last couple of minutes a few more case studies by adopting the perspective of transparency in P2B relationship and dispute resolution that I already used before. So my first object of observation is Tmall Global. Some quick words on the platform for those of you who don't know what Tmall Global is. This is one of the Alibaba's platform, once again, and it has a focus on cross-border e-commerce. Basically, Tmall Global intends to fulfill the increasing demand by Chinese consumers for international products and brands. And the platform is therefore an interesting gateway to the Chinese market for businesses, for example, European businesses. Now, Tmall Global offers extensive dispute resolution service for adjudicating disputes between sellers and buyers. And here we have an extract from Tmall Global Dispute Resolution Rules, which I would say are a very impressive document. The rules provide, and a very complex one as well, the rules provide both substantial standard for adjudication and as well as procedural rules. And you see some of this provision on the screen, some procedural rules. So essentially what we can spot, these are just example, provision number 40 points out the fact that T-Mobile Global may decide to extend its jurisdiction at its sole discretion. So we have a certain degree of uncertainty there. Then we have another very important feature of T-Mobile Global dispute resolution procedure, which is the possibility of an automatic execution of the platform decision, thanks to the interaction with Alipay payment service, which is the Alibaba Group's payment service. And therefore, we have the possibility for automatic transfer of funds whenever a T-Mobile Global reaches a certain conclusion on the dispute. And we discussed of appeal before. The only remedy that a party, so in our perspective, a seller is left with in case it does not agree with T-Mobile Global's decision is a recourse to arbitration, which I mentioned may not be exactly a proportionate measure for dispute resolution in e-commerce disputes. Now, very quickly, so AliExpress is another interesting platform, is once again another of Alibaba's marketplace which connect consumers from around the world with manufacturers and distributors which are based in China. So once again, the focus here is cross-border e-commerce with many EU brands, of course, manufacturing in China and then selling through AliExpress. What you see here is an extract of the service agreement that applies to EU sellers operating on AliExpress platform. And here we have, well, actually a quite very few information. We observe that there is an emphasis on the use of internal complaint handling procedure, which the only information we know is that it is managed through this seller support online chat. We have also mediation mentioned, but is not really encouraged or promoted by the platform. And finally, my very last example, we look at here Alipay term and condition applicable to EU businesses. Now, I already mentioned that Alipay provides payment for service for transaction on Alibaba e-commerce platforms and many other platforms such as Uber or Airbnb. Here we have some degree of transparency. It's pretty interesting. First of all, it's worth mentioning that the term and condition require the merchant to emphasize that he or she is raising a complaint. This is a clear sign that the management of the internal complaint handling system is done through artificial intelligence. Therefore, the platform wants us to clearly state that we are making a complaint, otherwise the system will not understand a complaint that has been raised. And also we have some degree of transparency, at least in timeline. So we have a pretty extensive timeline on the duration of this dispute resolution system. However, we really do not know on the basis of which rules and internal policies disputes are resolved. Now, I just want to briefly conclude by saying that it's very difficult for me to draw some conclusion on such complex issue, and my purpose with this presentation, as I mentioned, is just to add a further perspective to our debate. Of course, platforms are a global trade phenomenon, and their role in dispute resolution is not yet fully explored. Thank you so much for your attention.
Thank you, Angela, for having explored this very important role of online platform in dispute resolution. And your talk has been very interesting. You have outlined the changes, the important changes introduced by the new European regulatory framework, namely EU Regulation number 1150 of 2019 and the Digital Service Act, which is designed to protect businesses dealing with platform also regarding the complaint system, the internal complaint system. And I also really appreciated your analysis of the online dispute resolution mechanism put in place by Amazon and platforms belonging to the Alibaba group. It's really a new frontier of the research, so thank you very much. And now, the relevance of international commercial dispute resolution tools within the context of BRI initiative is the focus also of the presentation entitled The Construction and Competition of the BRI International Commercial Dispute Resolution Center, which will be presented by Professor Yuan Zhuan. Professor Yuan is lecturer and associate professor at the School of Law at the University of Shanghai, and Executive Vice President and Secretary General of the ADR and Arbitration Institute of the University of Shanghai. So please, Professor Yuan, the floor is yours.
So I will talk about two parts for my presentation. The first is about new legal hubs in BRI countries. The second part is China International Commercial Court, CICC. So for the new legal hubs, we can see the new legal hub is one-stop shops. At the moment, one-stop shops for cross-border commercial dispute resolution, often found in financial centers. New legal hubs address the problems of the legitimacy deficit of host states and also insufficient economic growth. They do so by optimizing conflicts of law rules, namely choice of forum and efficiency of procedure, attracting international parties to the harbor venue. New legal hub in BRI countries like Hong Kong, Singapore, Dubai, Astana, Shanghai, Shenzhen, and Beijing. New legal hubs are modern versions of multi-door courthouse. The idea of the one-stop shop new legal hub derives from later legal scholar Frank Sanders' concept of the multi-door courthouse. Multi-door courthouse means that the courts of the future would provide parties with a menu of dispute resolution mechanism and offer not just litigation, but also mediation, arbitration, and ombudsman with an intake office to triage disputes. Secondly, new legal hubs overlap with other sectoral hubs like financial centers. For example, as centers of finance, hubs require clear rules for creating capital markets. There are two categories for new legal hubs. They are organic and artificial. Organic legal hubs, like Hong Kong, Singapore. A number of variables differentiate the two categories, including time and the material of the market. Organic hubs have evolved over a long period of time and tend to have more mature legal service industries. They are supply-driven. The dense supply of the legal services establishes the reputation of new legal hub in a kind of past dependence. The more that a certain jurisdiction supplies the legal service, the more demand grows. Another category of new legal hub is artificial hub. There are artificial hubs like Shanghai, Shenzhen, Dubai, and Astana and Beijing. Artificial hubs are newer. In artificial hubs, there are also lawyers who supply the law for transaction through choice of law provisions. But the legal service industry is less mature than in organic hubs. Let us see the figure, the spectrum of legal hubs. You can see that the Hong Kong and Singapore are top-tier hubs. Their attributes for organic hubs involve over longer period of time, more mature legal service, and supply-driven, and more integrated into formal British Empire. And for Shanghai, Shenzhen, DIFC, AFC is artificial. They are artificial, involve over short period of time, less mature legal service and demand driven, and less integrated into former British Empire. And also, there are also the interaction between new legal hubs and the host states. New legal hubs and their host states are constantly interacting with each other as hubs and states respond to the uncertainty of international political economy. Certain new legal hubs, in particular, like those organic hubs like Hong Kong and Singapore, have been relatively successful in facilitating international commercial transaction and benefiting the city-state. Perhaps China is the ideal case to test the potential for hubs to positively impact the host state. Shanghai judiciary, for example, has made a major push to internationalize. This includes the Shanghai High People's Court's application of foreign law in 10 cases since 2014, and the Shanghai Court's processing of some 2,600 cases involving PRI states since 2013. There are new legal hubs in China, like Shanghai. Shanghai courts are adopting bilingual Chinese-English policies, at least when they present themselves to potential parties. Shanghai authorities want their hub to be accessible to foreign parties. And the Asian Pacific arbitration hub is also the goal, maybe as a goal of the Shanghai to Shanghai government. The Shanghai city government has issued several or many measures to support the hub's establishment. And Shenzhen also in Shenzhen they are like there may be the well-known arbitration institute commission, Shenzhen International Arbitration Commission. Also, there are new dispute resolution center set up in Shenzhen to handle disputes concerning Hong Kong, Macau related commercial disputes, including by arbitration and mediation. And also in Beijing, we know in Beijing, there are CITEC, the biggest arbitration commission in China, and also like Beijing International Arbitration Commission. So there are, so we can see that in Beijing, there are arbitration center, there are two commissions in Beijing, and also in Beijing, we can see the CICC inter-hub networks. China may be the jurisdiction will witness the largest growth in new legal hub in the near term. There are efforts to bring transnational law to the PRC jurisdiction so that foreign parties must adjudicate, arbitrate, or mediate with the PRC. So China is not only building its own hubs like Shenzhen, Shanghai, Beijing, but also starting to create its own inter-hub networks, CICC. So then I will turn to my second part. Second part is about the China International Commercial Court, CICC. CICC, the BRI, we can talk about the background of the CICC. The BRI ambitiously aspires to expand regional markets and facilitate economic integration across Asia, Africa, and Europe. It has been regarded as a game changer in the landscape of dispute resolution and is expected to trigger a proliferation of adjudication business. The CICC was established in 2018 to cater to China's leading role in the BRI, with the specific goal of facilitating dispute resolution among BRI countries. The CICC is governed by the provision of the SPC on several issues regarding the establishment of the International Commercial Court. We can call it CICC provisions. There are two cores, and CICC consists of two cores. The first CICC is based in Shenzhen for handling BRI-related international commercial disputes arising out of the sea-based maritime Silk Road, and the second CICC in Xi'an, Shanxi province, for handling BRI-related international commercial disputes arising out of land-based Silk Road economic belt. Shenzhen was chosen for its traditional role as a test bed of new legal economic policies and for being close to Guangdong, Hong Kong, Macau, Great Bay Area. Xi'an was chosen in part for its historical position as the starting point of the Asian Silk Road. And the fourth civil division of the China's SPC in Beijing, which specialized in trials of international commercial disputes in China, also is responsible for the coordinating and guiding the two CICC. And there are 16 judges and the ICE committee. All 16 judges appointed to CICC are mainland Chinese, selected from senior judges familiar with international laws and norms and proficient in English and Chinese. 9 of the 16 judges either visited or studied at a university out of China. The introduction of foreign judges has been prohibited by Chinese law. And faced with this obstacle, the CICC innovatively introduced international expertise through its niche product, the International Commercial Expert Committee. We can call it the ICE Committee. And Professor Shen Sibao is also the members of the ICE Committee. So members of the ICE Committee may have two key duties. The first duty is to preside over mediation. The second is to provide expert opinions on finding of foreign law. The mediation duty of ICE Committee is an integral part of CICC ambition to set up a one-stop multi-tile dispute resolution platform as prescribed by Article 11 of the CICC provisions, with the promotion of ARP-MED as one of its top priorities. The most notable of the many groundbreaking features of the ICE Committee is that if a settlement agreement has been reached after the presiding of mediation by the ICE members, the CICC may issue a judgment based on the mediation settlement agreement. So in this way, the foreign members of the ICE committee are indirectly allowed to pass judgments via the mediation mechanism. This is by far the most liberal feature of the CICC in terms of internationalization, and may potentially somewhat offset the international concerns about and skepticism of its lack of international elements. CICC also allows the ICE committee to give advice on foreign laws. Another statutory obstacle is Article 262 of Chinese Civil Procedure Law, which stipulates that hearing of foreign-related cases must be in the language of commonly used in China. The extent of CICC introduction of international elements stop at the ICE committee. This may affect CICC competitiveness when all other ICCs in Asia and along the BRI roadmap features foreign judges such as SICC in Singapore, AIFC in Kazakhstan, and ICCs in the Middle East. Despite the CICC potential limitation, the court could benefit from the BRI directly. Commercial parties in BRI-related contracts influenced by China's economic power may specifically designate the CICC for the dispute resolution. On the other hand, mirroring the SICC's placement as a subdivisions of the Singapore High Court, the CICC was made a subdivision of SPC in Beijing, a structure that guarantees a healthy flow of case by transfer and refers. Thus, the CICC, like SICC, could have a stable intake of cases. There are three features of CICC. First, ICE committee's function as a mediator and a foreign law expert is no doubt a sign of internationalization by the CICC. The fact that the mediation settlement agreement can be converted into the CICC judgment is arguably in parallel with the DIFC calls innovation to convert judgments into arbitral awards. Secondly, the CICC actively embraces the concept of one-stop center for multi-tailed approaches to international commercial dispute resolution service, integrating litigation, arbitration, and mediation. Last but not least, CICC strives to achieve technological innovation. The court supports an online process for case acceptance, payment, service of process, mediation, file inspection, evidence exchange, pretrial preparation, and hearings. The case management and the pretrial conference can be held via online video calls. The party may also apply for online video trial. So that's all. That's for my presentation. Thanks for your listening.
Thank you.
It's okay.
Thank you, Professor Yuan. Thank you very much for
Welcome.
your very. Thank you.
I can stop share. Okay. Okay.
Okay, thank you for your very interesting description and analysis of the international commercial dispute resolution mechanism set up by China, and your important observations about the competition between different countries and regions to provide cross-border commercial dispute resolution services. And this very huge, important investment by China on the new legal apps and the inter-apps network. Could you kindly send your slides to Elena or Ru? Let
Yeah,
us.
okay. I have
Okay.
sent. Okay.
Thank you very much. They are very
Yeah,
precious for
welcome.
us. Thanks. And I have the honor to listen to Professor Shen Shebao video talk, I think. We have a video talk entitled Moving Forward Rule of Law on Belt and Road Initiative. Professor Shen is chairman of the ADR and Arbitration Commission of ICC China, just mentioned by Susan, and chairman of the Sanctioned Court of International Arbitration.
Yeah, Professor, and a really distinguished professor, Lewis, ladies and gentlemen, good afternoon. I'm really very pleased and honored to be here to join this forum. My presentation will focus on moving forward rule of law on Belt and Road Initiative. As you know, some of you know well, it has been over 10 years since China initiated the Belt and Road construction. In past decade, Belt and Road Initiative has made great progress. For example, in past 10 years, China has signed more than 200 collaboration documents with 151 countries and 32 international organizations. And the Supreme People's Court in China has issued a number of judicial interpretation, and the Chinese government has promulgated over 70 regulations, all of which are related to Belt and Road construction. Now there are almost 3,000 collaboration projects has been established along Belt and Road Initiative area. So the practice has proved that construction of Belt and Road is conducive to China's opening up, especially to some developing countries. Over past decade, Belt and Road Initiative has promoted global development and prosperity in many industries. At the present, it's facing the new task of moving from further reducing risks to high quality development. President Xi Jinping deeply pointed out in the report of 20th CPC National Congress that we will implement more proactive opening up strategy and jointly build the Belt and Road, making it a popular international public product and international cooperation platform. I think the report at least raises following three major issues. First one, Belt and Road is an important part of China's vision of more proactive opening up. Second, we should build the Belt and Road into welcomed international public product and a welcomed international cooperation platform. So, all countries and enterprises which are interested in Belt and Road could jointly build the Belt and Road with high quality together. The report of the 20th National Congress of CPC has made it clear that prospect of Belt and Road construction is to make it a globally popular international public product and international cooperation platform, which means that all countries can enjoy or use this product and platform to develop their own economy. However, in order to achieve this aim, all countries over the world should make efforts, especially the country along the Belt and the Road area, should make great contributions to joint construction. Among them, I think rule of law construction and the rule of law cooperation is one of the keys to jointly build the Belt and the Road. As for content of rule of law cooperation concerning Belt and the Road, I think it includes, but not limited to the following. One, all countries along Belt and the Road area should jointly abide by the current international conventions, multilateral or bilateral treaties, and international practice that have been signed and are still in force, such as CISG or New York Convention. CISG means Convention of International Sales of the Goods. As we all know that without the New York Convention, all international arbitration would lose its cornerstone. If no country complies CISG, then nearly half of the countries, or nearly all the major trading countries, may lose the trade standards and the rules. And the Belt and the Road as platform for international trade, for international economic cooperation would be almost impossible to exist as well. Therefore, I think in order to make the Belt and the Road as a globally popular platform for international cooperation, we must establish and implement set of international rules, practices, and business standards. Of course, we should abide by existing effective rules first, and then to create the new proper one, gradually following needs and development. 2. China should tell the story and share his experience on building rule of law. China would encourage and work with all countries along the Belt and the Road area to jointly promote and improve process and quality of the rule of law. 3. We should advocate the freedom of contract and the spirit of contract. The spirit of contract, which means all the contract signed must be fulfilled. This is a crucial of all economic and commercial activities on Belt and the Road. 4. We should promote in creative ways and collaboration development in the area of legislative, judicial, law enforcement, and legal services in the countries along the Belt and Road construction. And our legal academic circles should also enhance communications and exchange discussion some relevant issues about the rule of law in order to settle the common problems arising from construction of Belt and Road. Finally, I would like to tell you a new event happened in China. Now, for harbors for international commercial arbitrations in China are forming. They are respectively in Beijing, Shanghai, the two areas. Another place is Guangdong, Hong Kong, Macau, that we call Great Bay Area. 粤港澳大湾区 Guangdong, Hong Kong, Macau, Great Bay Area. The fourth place is Hainan Free Trade Port. Hainan 自由贸易港. Also, you see, in Hainan government just issued new regulations that foreign arbitration institution, or like RCC, whenever London Arbitration Court, International Arbitration, or that everywhere in different countries are permitted to establish their office. Not only establish office, also encourage this new office conduct their arbitration work. So it's the first time to permit and encourage a foreign arbitration institution to do their business in China. It's good news. That means China's opening up, the policy will be continued. It will continue. And I think now spring is coming in Beijing. So welcome all of my friends and participants in this seminar. We will visit China, especially welcome you to visit Beijing, Shanghai, Shenzhen, Guangzhou, Beishan, Guangsheng, and Hainan. We call free trade port. So thank you. Thank you very much. I'm eager to meet you in China.
Thanks. I think we couldn't have a better conclusion. We couldn't have a better conclusion for our seminar than Professor Shen video talk and invitation to visit China and Chinese new legal apps. I really would thank Professor Shen for sending his presentation, his video presentation, which has underlined the importance of creating a regulatory framework, including also rule of law and freedom of contract to efficiently resolve pre-commercial disputes. So now, are there questions for our distinguished speakers?
Yes, there is a question for Professor Hawker. In your presentation, you highlighted the change of arbitration procedures managed by Chinese institutions, in particular with regard to arbitrators' approach. Do you think that in the next future, Chinese arbitration institutions could grow in their competitiveness with other renowned Western arbitration institutions?
It's a question for Professor Yuan.
Professor Hawker.
we can also
for Professor Oker, okay.
Also, I think it is suitable also for Professor Yuan if they both want to answer and dialogue on this matter, because we had very interesting in-person presentations by them. Thank you very much.
Okay, thank you. Yeah, so I can answer the question about you mean are there any limitation for foreign arbitrators in acting as arbitrator in Chinese international legal rules, legal hubs? You mean that question? I see the question.
No, actually, it was a question about the growth in competitiveness by Chinese arbitration institutions since their growing importance with regard to other Western arbitration institutions.
Arbitration, yeah, you mean there are, you mean, yeah, can you repeat the question again? So I just, no good connection.
Yes, sorry. The question was for both Professor Hawker and you, and was about sorry, I'm checking it, about the change in Chinese arbitration institutions approach. So if do you think that in the next future Chinese arbitration institutions could grow in their competitiveness with other Western institutions that are renowned?
Okay, Elena, we can start with Susan's answer.
Yes.
Because the question was originally to Susan,
For
and
Susan.
afterward, Professor Yuan, if she wants, can.
Okay,
add.
yeah, I got a
Thanks.
question. Okay,
Thanks.
yeah, you first.
Okay, I'm very interested to hear what Professor Yuan thinks. I could spend forever answering this question, but I think if I had to answer it in one word or under a time-limited frame, I would say yes, I do. Partly because I think all things are possible, partly because I think there is an inevitable drive in China to, across the board with everything, to compete and be, at the forefront of what is happening in the world. And so I don't see why that would not include international arbitration and international litigation. I think that trade arbitration and litigation are special in the sense that they're very much, both forums and both ethoses are driven to promote trade. And it's a bit what Devlin said when he first was appointed as a judge. Commercial law and commercial practice must keep hand in hand with each other. And I think that happens across the board. And I don't see why it wouldn't happen in China. And I think if China wants to promote the BRI and it wants to be a credible player, then, well, it's like step up to the plate. And I don't see anything any more insular in reality in China than we are here. We are more established in London, but Singapore has grown enormously as a trade dispute resolution center. Hong Kong is there, scratching around at not being such a second player anymore, but coming to the forefront. So I think, yes, I think it would be backwards looking to think where we are now and to think of the BRI issues as new, which they are, and think that we won't move on from that. So the answer is, I would be very surprised. I would be very surprised if, and I don't know what is meant by the next future. Is that the next generation? I don't know whether it can happen as quickly as that. I'm not part of Chinese culture and Chinese efforts inland to promote BRI dispute resolution. I think it's not impossible. I think it is inevitable that that will happen, if not the next generation, but certainly generations to come. And the international cooperation and the inviting of visiting lawyers, and the fact that, you know, the city law firms, international shipping trade firms, have all set up highly successfully in mainland China, you know, with a mixture of Western and Chinese lawyers. So I think the answer, personally, I think the answer must be yes. Professor Yuan?
Yeah, I'm here. Yeah, okay. Yeah, it's my turn. Yeah, in my opinion, as I know the situation of the Chinese legal hubs, including arbitration hubs, yeah, will got the high competitiveness in the future. Yeah, and as we know, there are many measures to from city government to support the arbitration hubs establishment, like in Shanghai, the free trade zone. In free trade zone, and like a foreign leading arbitration institute can establish their office in free trade zones. So, and also under the measures issued by the government, and there are many, like encourage the arbitration to be maybe in Shanghai, that we have the goal to establish Asian Pacific Arbitration Center. So, and also after the Singapore new convention, and also there are also like international mediation center. We are also have some institute like mediation center. Also, they are make effort to do that, to make it a mediation in the future. So and like in Shanghai, and also like Shanghai financial courts, the financial court, and also other mediator court has have issued many like friendly arbitration like policy to support arbitration. So and now because the transparency for litigation, and many clients, many companies from China, and also like tended to choose arbitration because of the advantages of arbitration is confidentiality and also other efficiency. So under the BRI initiatives, as we know, Shanghai is a leading city of China, and it's also the leading city to like economic Asian. So now the government also encourage the company to invest BRI countries to choose arbitration as the means of dispute settlement. So I think and also in my opinion, and in the future, the arbitration or like new legal hubs will compete with other like leading arbitration committee, leading new legal hub like Hong Kong, Singapore. As we know, last like international arbitration surveys by Queen Mary's University, as we know, Beijing is maybe Beijing is number 6 and Shanghai is number 8 in the world. So we can see the future, they will got the high competitiveness. It's my opinion. Thank you.
Thank you, Professor Yen.
There is a question for Professor Zucconi Gali Fonseca and a further question for Professor Yuan. For Professor Zucconi Galli Fonseca, do you believe that the Belt and Road Initiative could promote a higher level of integration in the recognition of arbitrary ward or interim measures among the countries that are part of the initiative?
Well, I would say, first of all, that our new system of implementation of foreign interim measure can provide for an implementation of Belt and Road Initiative. This is the point. And I would say, as it seems, that interim measures are more facilitated. Foreign interim measure can come in our country easier than the awards, because the awards must be executed. There must be that must be recognized within the New York Convention, while the foreign interim measures are executed directly under the control of the court. But I think that the court, when controlling during the implementation of the interim measure, must look at the respect of some, I would say, some conditions which must be present, as the conformity to public order, Italian international public order, and the respect of the right of defense. So if the foreign institutions or arbitral proceedings respect this kind of important features, there will be no problem in executing in Italy. So I think that it's an exchange between the BRN and our system.
Thank you very much. For Professor Yuan, are there any limitation for foreign arbitrators enacting as arbitrator in Chinese international legal hubs?
Okay. No. Now for foreign arbitrator, so according to Chinese arbitration law, and the arbitration commissions can have the arbitrator list. So in their arbitrator list, and also can be listed as the foreign arbitrators can be listed in the list. So no limitation for foreign arbitrator in acting as arbitrator in Chinese legal hubs. The law has permitted.
Thank you very much. There is a question also for Dr. Felicetti, Angela Felicetti. In dealing with the Chinese e-commerce platform from a EU country, which one is the arbitration law that shall regulate the arbitration or mediation clause used by these platforms?
Well, thank you so much for the question. It's a very broad topic of international private law, actually. But what I would like to stress is that, well, first of all, we have to make a distinction among clauses applicable to consumers. And then as far as EU law is concerned, we have several issues with the validity of these clauses. While for businesses, well, it's often the case that general terms and conditions apply in cases of course, Asian-based platform, some form of Hong Kong arbitration or Singapore or many other instruments. But what I would really like to stress in this respect is this counter question, if you allow me to say, are we really looking at arbitration or mediation? Or whenever we are, this platform use these terms, particularly in respect with this sort of mediation procedure they implement within themselves, maybe we cannot recognize the parameters of mediation at all. So unless we have a proper mediation clause or arbitration clause in the common sense that we all recognize, we should also consider that intermediate level of internal complaint handling mechanism, and that is an uncharted territory. There is no rules applicable to that. It's an internal procedure, but we need some degree of transparency to be able to look into that as well, because otherwise we're missing out on a lot of rights of consumers and businesses as well. Thank you.
Thank you very much. I don't see any further questions so far.
Okay, so
Thank you.
please, Susan. Yes, Susan. No, your microphone is turned off. Okay.
Yes, I very much agree with what Angela has just said. In respect of trade, I have no view about what will happen with consumers. I'm sure that there are opportunities. The moment you've got trade is the moment you've got consumer opportunity. And to a certain extent, it's the desire of consumers for consumer opportunities that drives trade. But how that will pan out in dispute resolution, to my mind, is a totally separate question, because certainly here, consumer resolution is not as transparent as we might think, because although the court proceedings are open, nobody has any real interest in going down and listening, and they're not reported. So unless you've got somebody, something really high profile going on in the county court, it doesn't attract attention or interest. Whereas certainly the High Court is always full of people wanting to know what's going on. So I think that what happens with consumers is a totally different issue. I think that it will inevitably, as far as trade dispute resolution is concerned, I think it has to. And I think that's the end. It's just what I said in response to the question, do I think that they will grow in their competitiveness? Well, as my mother used to say, you either sink or swim, and it's your duty to swim on. I mean, and that really rather sums it up. I think that you cannot look at the culture and the changing face of China over the centuries and not see the enormous wealth of knowledge and expertise across the board in all aspects of life and say, no, they won't be competitive. And I think, so sink or swim, and I can't believe China will sink, so it will swim. And I think that in some ways it's swimmer beware to the rest of us, but we need that. The world is smaller now because it is more global. And we are dependent upon Chinese goods. And we are dependent upon Chinese expertise. The world is. Look at, the facilities for shipbreaking, large oil tankers that exist in China, and they don't exist in other parts of the world. And we need that, because we need safe and environmentally friendly shipwreck recycling. So yes, I absolutely agree with Angela, 100%.
Thank you, Susan. So no more question?
No.
And then today's seminar, I think, has come to an end. I really thank all the people who participated in today's workshop, and give a special thank to to the colleagues and friends that connecting from all over the world gave their contribution to the topic of alternative dispute resolution regarding the Belt and Road Initiative, and in doing so underlining the importance of the law and justice to build peaceful and fruitful relationships between people and countries. So let me conclude today's seminar by quoting the French writer Marguerite Yourcenar's most famous novel entitled Memoir of Adrian, to stress the importance of the rule of law and to have efficient and highly reliable legal instrument for settling international trade and investment disputes. Hadrian is the emperor who built a lasting peace in the Roman Empire, and it's him who speaks here. Even in the least important of towns, Rome will perpetuate herself whenever magistrates strive to demand just weight from merchants, to clean and light the streets, to combat disorder, slackness, superstition, and injustice, and to give broader and fairer interpretation to the laws. By doing this, Rome will endure to the end of the time. Thank you all for participating, and goodbye.
Thank you.
Thank you. Thank you.
Thank you.
Bye.
Bye.
Thank you. Thank you for everybody. Thank you for the opportunity. Thank you.
Thank you.
Thank you for the opportunity. Bye.
Thank you very much.
Bye-bye. Bye-bye.
Bye.
Bye-bye. Thank you. It's great.